Well, it looks like it is just noon, and we want to be cognizant of everybody's time, so we will get right into it. I'm Faith Whittaker, and I'm so excited that all of you joined us today to talk about these updates and very important topics. I'm a partner in the Cincinnati office, and I chair the Employment Practices Group. And with me, I have Alina Klimkina, Rachel McClintock, and Ashley Pack. I will have them introduce themselves. But we are going to talk about some updates that are really important for your clients. And just to give you a little background, I'm sure you already know, but our firm has about just under 100 attorneys in our labor and employment department. And that includes traditional labor, immigration, and workers' comp, and then employment practices. So we're coast to coast and really excited about our expansion in California, which I'll have Rachel talk about a little bit more, because a lot of you probably know California just operates a little bit differently. So with the sunshine, it has some other unique aspects. But with that, I will turn it over to Alina and Rachel.
So I'm Rachel McClintock. I am a labor and employment partner in the Los Angeles office. I've been with Dinsmore for about a year now. I'm actually coming up on my 1-year anniversary here on July 24th. Dinsmore didn't have very much of a presence in the L&E space out here in California, so we are really expanding our bench with our growing group. When I came here, we had three attorneys that were in the new LA L&E group, and now we are up to, I think, 8. We've got a new one starting, a new associate starting on Monday. So we also have expanded just kind of the services that we can provide to clients. I know a lot of you do business out here in California. We also have a partner who's dedicated to counseling, so we can be at your service whenever your needs might arise. So in addition to the litigation aspect, we also have that. I will go ahead and hand it over to Alina to introduce herself before we jump into the substance.
Thank you. I'll be brief. Welcome, everyone. Alina Klimkina. I'm a partner in labor and employment in our office. Although I work with clients and individuals and entities really across the country, of course, predominantly in our region, and really looking forward to the conversation today. These are very new, exciting, interesting developments, but Rachel and I, in our conversations of preparing for today's presentation, realized there has not really been this robust body of litigation or interpretive guidance related to the Pregnant Workers Fairness Act. So we're all learning together. We look forward to hearing your questions. Of course, lots of familiar faces in the audience, so really excited to talk about this with you today. We have some nuts and bolts that are a little less exciting and saucy than perhaps a typical presentation, but we'll try to throw in some examples as well as we talk about our subject matter. So without further ado, Rachel, go ahead.
Great. So as Alina said, we're here to discuss the accommodations and navigating the Pregnant Workers Fairness Act, otherwise known as the PWFA. There are our beautiful faces, which you guys can see here anyway, and we just introduced ourselves, so I will move on to the substance. So what is this? Well, first, let me just have the caveat by saying that if you've done business in California or do business in California, none of this will really change the landscape. So really, it's pretty much just the federal government catching up with what California basically already does. As Faith mentioned, things are a little bit different out here in California. So a lot of this might not be new to you just from an overarching perspective, but let's just talk about really what this new PWFA does nationally. So the goal ultimately is to keep pregnant women safely employed and insured. The PWFA requires a covered employer to provide a reasonable accommodation to a qualified employees or applicants' known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship, which I'm sure is not a foreign concept to those on here. The PWFA applies only to accommodations. It does not replace federal, state, or local laws that are more protective of applicants and employees affected by pregnancy, childbirth, or related medical conditions. And in California, we've got the FEHA and PDL that also provide separate and more expansive protections to pregnant workers. So next slide, please. So why do we need it? There are gaps in the federal legal protections for workers affected by pregnancy, childbirth, or related medical conditions, even though they might have certain rights existing under civil rights laws. For example, the FMLA only provides unpaid leave. It does not speak to reasonable accommodations. And under the ADA, pregnancy itself is not a disability. That's also true under the FEHA, but as you know, in California, courts and fact finders are going to find a way to protect a pregnant woman or anybody affected by pregnancy. So despite that it's not technically a disability, they're always going to find a way to get the employer on the hook to provide whatever the pregnant employee or covered employee actually needs. So they're going to say that you could always have done more. I think the overarching theme of this is going to be that basically, if you have a pregnant woman, even in California or anywhere, or anybody that's affected by childbirth or related medical conditions, and they're asking for an accommodation, with the exception of very limited circumstances that we're going to discuss later, just accommodate and do everything that you can to make sure that that individual has what they need. So it also providing these protections is critical to the economic security of women workers and their families. Women are the primary sole or co-breadwinners in nearly 64% of families, and there's an increasing majority of women in the US who give birth and are in the labor force. Women are working later into their pregnancies, and the lack of accommodations for covered workers meant that pregnant workers were forced to choose between their job and a paycheck, and this alleviates some of those concerns for them. There's also a determination that a lot of the accommodations that are going to be sought are pretty much low cost or of no cost to an employer. For example, we'll dig in. Some other accommodations would be additional breaks, needing water, etc., things that are typically not going to cost an employer a whole lot of money. And then ultimately, at the end of the day, the general percentage of covered employees in any given year will be relatively small because not every pregnant woman or person affected by childbirth or pregnancy is actually going to ultimately need an accommodation. Next slide, please. So when was it effective? So the initial regulation was effective on June 27th, 2003. The final EEOC regulations went into effect on April 15th, 2024. The final regulation was effective on June 18th, 2024, so just very recently, and we are currently in the comments period, which began on June 27th, 2024. Next slide, please.
And Rachel and I were talking, by the way, the comment period, it is probably unlikely that there will be any substantive or substantial changes, and we'll talk about some of the litigation that has already resulted since the Act's implementation. So that is more likely really to shake things up than the comment period, but remains to be seen. So who is actually protected by this new law? It applies to both qualified employees and qualified applicants. So covers those pre-employment. If you have somebody who is an applicant and pregnant, this act would apply to that individual. First, an employee or applicant who can perform the essential functions of the position with or without reasonable accommodation is qualified. The qualification is really important because the person has to be able to perform the essential functions of the job, and those are fundamental duties of a given position. So if this language sounds very familiar to you, it should. It is really directly tied or connected in our verbiage to the ADA, so hopefully very familiar, and the terminology has a lot of the similar meanings, which we'll talk about in a minute as well. If an employee cannot perform the essential functions of the job with or without a reasonable accommodation, that person could still be qualified if they can't do the essential functions, as long as the inability is temporary, the employee can perform the functions in the near future, and the inability to perform the essential functions can be reasonably accommodated. So when you think about it, it makes sense. We may occasionally argue in a disability discrimination case, for instance, or an accommodation case otherwise, that the individual has a fleeting or temporary inability to perform the essential functions or some functions of the position, and so therefore it doesn't actually have a disability as a matter of law. This argument is really inapplicable under this new law because a person remains qualified and still even if they cannot perform the job temporarily. This, of course, makes sense when somebody is pregnant or expecting or undergoing treatments because those conditions are temporary in nature. So if you have an applicant who really can't perform certain portions of the job right now, but will be able to do them in the near future, once they complete, for instance, treatment or fertility treatment or delivers a child, that person could still be qualified for the job. So drawing some distinctions here with the ADA and some other laws which offer protections. Under this new act, a limitation, so this is important as well, is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. This is, of course, the most unique aspect of this particular law. It really is focused on anything related to pregnancy, period. Differentiating it, as we've done with the ADA, for instance, or the California's counterpart and equivalent, it is that here there's a physical or mental condition that is related to pregnancy that can still be a limitation, even if it's not a disability. So at first blush, it seems like you have this sort of duplicative act, the Pregnant Workers Fairness Act, which provides similar protections. You may have thought a year ago, or even as recently as a few months ago, that it's a little redundant, but it's not. It is very targeted, very focused on pregnancy and those related conditions. So even if somebody's pregnancy or related condition does not fall within protections under the ADA, it will under this law. And so, of course, broadens the spectrum of protection and accommodations for persons who are pregnant or have related conditions. This relates to conditions which both precede pregnancy and which postdate pregnancy. So, for instance, if you have a woman who delivers a child or goes through a completely normal pregnancy and childbirth, but then has complications postpartum, like a C-section or post-delivery complications with blood pressure, all of that would be covered by this. I think one that everyone hears about is postpartum depression. That's one that is specifically covered by this act as well. And it can be that the individual or applicant has to take actions for their health of their pregnancy, not, for instance, not being around certain chemicals, not working in the heat, limiting or avoiding certain tasks or risks. The EEOC has provided some really comprehensive broad guidance. If an employee needs to attend healthcare appointments for pregnancy, childbirth, or related medical conditions, all of that is going to be protected by the act as well. Next slide, please. And while the slide is switching, really important to keep in mind here, lactation, fertility treatment, any kind of birth control and abortion are also protected by the act. So one area where we really anticipate there being ongoing litigation or perhaps issues and questions is lactation. It tends to be the subject of many questions that we receive. I've had many of those, for example, in healthcare, where you have the need for employees who are not necessarily taking 15, 20-minute breaks every 2 hours or every 3 hours, where there's need for continuity of work productivity, but lactation is going to be very protected by the PWFA, so keep that in mind. So who must accommodate? Very briefly, this applies to essentially all employers, private, public, as long as you have 15 or more employees. Now, there may be some states like California, for instance, that have state regulations that trigger additional applicability of laws for employers with fewer than 15 employees, but 15 is the threshold and it applies essentially across the board to almost every employer. Next slide, please. Sometimes we, as employers, we look for magic words or some sort of very express request for an accommodation. Oftentimes, of course, we like to hear a very direct or express request, or we look for our employees to use forms or follow the specific process that the employer has. Here, the EEOC really has not endorsed that, traditional approach. An employee or applicant is not required to make a very specific or express request. As long as they have conveyed to the employer that there is a limitation and an adjustment is needed for a change in the working conditions, the employer has an obligation to engage in the interactive process. So for example, some of the requests that the EEOC specifically lists as examples are vague, not necessarily traditional under the ADA, and very, very simple. One example is I need more bathroom breaks because of my pregnancy. Another one is I'm having trouble getting to work at my scheduled starting time because of morning sickness. Or I need time off from work to attend a medical appointment because of my pregnancy. The request does not have to be accompanied by doctor's note or some sort of formal process or form. Now, you can still request employees to complete or to follow the standard process that the employer has in place. But the EEOC has taken a very strong position that employees can make requests which are really pretty vague and not necessarily ones that you would expect to see under the traditional ADA process. Now, everyone hopefully knows the interactive process only means that the employer and the employee must have some sort of communication, engage in that interactive conversation of determining what kind of action should be taken to adjust or change the working conditions or the piece that is affecting the location of the employee. If it does not cause an undue hardship to the employer's business, the employer generally must provide a reasonable accommodation, regardless of how great or how robust the employee's or specific robust the employee's request is. Next slide, please.
Alina, if I may just jump in and just kind of piggyback, I had a case back in 2022, 2023, where there was an employee who was pregnant and she was accommodated with leave at the beginning of her pregnancy because it was high risk. She was released. She had no further request for accommodation, no doctor's notes, no anything. But what she was saying, she was in the healthcare industry and she was a nurse. And she said, you know, I'm having trouble working these 10-hour shifts because I'm really hungry in the morning, but the way that the shifts are currently scheduled, it's making me hungry before my lunchtime. And so can I please I'd like to work a later shift so I can eat before I come in. And, you know, we argued that pregnancy itself was not a disability that required the accommodation. And the arbitrator found, well, while that's technically true, what she said should have triggered the interactive process. And then you should have then engaged and figured out what she needed. So again, I just kind of want to go back to the idea that despite the fact that this law wasn't in existence, and despite the fact that, you know, pregnancy itself is not a disability in California, it doesn't change anything really from the landscape perspective, because the expectation is that the interactive process should have been engaged with, even on such a big comment like, I need to eat a little bit earlier. So again, going back to the whole, it doesn't have to be a definitive request. There doesn't have to be a doctor's note. It should be triggered. So I think that's a really important thing to think about.
Yeah, and to add even to that, I can't underscore the importance of engaging in the interactive process. This really goes beyond this new act. It is really something that the EEOC and courts look for, the interactive process, and whether or not the employer actually considered the request for an accommodation. The EEOC across the board, I think, just to step outside the box of this particular new law, the EEOC across the board has made ADA claims and disability claims generally a priority. We know this has been true throughout 2024. It is really important to them. They're looking at these claims very closely. And to the extent that an employer made a request, whether it's indirect or vague, and the employer did not or failed to engage in the interactive process, the EEOC will more likely than not view it as a potential violation. And of course, courts look to the EEOC guidance as well. They look to the body of case law, but the claims are changing and they're really ever evolving. And the EEOC is now very, very clearly telling us that you have to engage in the interactive process, and that things which traditionally would not have triggered maybe the interactive process will trigger it now, specifically with respect to this law. But really, we would encourage you to think about it broadly, just beyond that as well, because that's really how the EEOC is looking at other disability requests as well. So speaking
Sorry,
of
Alina,
requests,
I don't want to interrupt, but it's Autumn's sharing her screen, so she can't mute everybody. So if you would not mind for the folks in the audience to mute, that would be really helpful. Thank you.
thank you. So what can an employer actually request? Well, along those same lines, the EEOC is really moving away from large formalities and really moving away from requiring a doctor's note for any requested accommodation. Under the PWFA, employers can only request documentation that is supporting if it is reasonably needed for the employer to just determine whether to grant the requested accommodation under the circumstances. But this is really pretty limited. And again, the EEOC is being very bold in it. It's unreasonable that EEOC has told us when the limitation and the need for a reasonable accommodation is obvious. And when you think about it practically, many times with pregnancy it is, right? When, for instance, you have somebody that is ill or having difficulties maybe holding their food down at work, the need for an accommodation of potentially taking breaks from morning sickness is going to be much more obvious. The employer already has sufficient information to support a known limitation related to pregnancy, or the request is one of the 4 predictable assessment accommodations, which we'll discuss here in a minute. So what this means is that the EEOC really thinks that it is going to be unreasonable in many instances for the employer to request documentation from an employee or applicant. Now, an obvious example of when documentation may be necessary is, for instance, when an employee or applicant is undergoing fertility treatment, or early on when, you know, the desired or potential pregnancy is really not obvious. Those kinds of situations. But beyond that, when an employee is visibly pregnant or has requested something related to a limitation that is really well known with pregnancy or childbirth, it is going to be very difficult for the employer to justify requesting documentation from either an applicant or an employee. It's a pretty limited set of circumstances. Many employers ask for documentation that supports the request as a matter of course. Don't do it. The EEOC and courts, as a result, will not look kindly on it, and it's really expressly prohibited by this act. So the best practice here is to ask an employee for a description of the accommodation request or what they're looking for, and then an estimated timeline for that accommodation. So we talked earlier about how an individual could still be qualified to perform the essential functions of the job with limitations if that limitation, for instance, is temporary in nature, or if there is some sort of finite time period. With most pregnancy-related limitations, there is going to be some sort of finite limitation period for it. So that's something that you're well within a right to ask for, that descriptive narrative and an estimated timeline for the accommodation. And then, of course, Rachel can chime in about California, but when a California employer does request an accommodation, that has to comply both with the federal law standards and with California law as well. Next slide.
So what should the employer not request when it comes to documentation? So where the limitation and the need for an adjustment or change at work due to the limitation is obvious, something that Alina just kind of covered, but to provide you with an example, for example, an obviously pregnant woman who seeks a bigger uniform because she is growing a child and she cannot fit into the original uniform. So the employer should not reasonably ask the employee in that instance for documentation to support the requested accommodation. Again, if the employer already knows about the limitation and the adjustment or change at work due to the limitation, for example, if the employee has already provided enough information that they have morning sickness due to a pregnancy and they need a later start time, the employer cannot demand a new doctor's note every single time the employee uses the accommodation coming in later. So in the example that I provided you earlier with that, the previous case that I had, the employer was already on notice that she had a high-risk pregnancy. She required leave. They actually even put her in a temporary light duty position. They knew that she would require accommodations. And so when she told them that she needed a schedule change, that should have been something that would not necessarily have required a doctor's note. It was obvious and the employer knew about it. Another situation is if the employee is currently pregnant and needs a break for the bathroom, to eat or drink, needs to carry water with them, or needs to stand. And we're going to talk about that a little bit in further detail in the next slide or so. Again, if the employee is lactating and needs modifications to pump at work or nurse during working hours, and the employer should also not ask an employee for documentation in a situation where it normally wouldn't. So for example, if an employer has a policy where the employee need not provide a doctor's note if they're going to have 3 consecutive days off for sickness, then they can't then require the pregnant employee after missing 1 day to bring in a note. Next slide, please. So what are some examples of reasonable accommodation? This just outlines some bullet points. Again, this is always going to be, as the typical attorney response, it depends, or it's a case-by-case assessment, but that's always true. Again, leaning towards the idea of wanting to accommodate, doing what we can, and always, again, engaging in the interactive process to find out what the employee's needs are. So some examples of the reasonable accommodation would be additional longer or more flexible breaks, changing food and drink policies to allow for food and drink where maybe otherwise it would not, modifying the facilities, even changing equipment, devices, workstations, uniforms, things like that, changing uniforms or dress codes or providing safety equipment that fits. Also in the example that I was giving you earlier, another accommodation that the pregnant employee requested was just not to be around x-rays. That would be a reasonable thing because I think, especially in healthcare, it's a known danger to a pregnant woman. And so that should have also been an accommodation that was just granted, or at least started the interactive process of what other things that person could have done in a hospital setting to not expose themselves and their child to a risk of x-ray. Changing a work schedule, working from home, doing a temporary assignment or light duty that might otherwise accommodate the pregnant woman, temporary suspension of one or more essential functions of a job, which unlike the ADA and the FEHA, this particular statute requires. Of course, leave for healthcare appointments, light duty, help. Sometimes we can have, the employer can provide an additional employee to help, for example, in the healthcare setting, a nurse move a patient so that they're not straining themselves when they otherwise, if they were not pregnant, would be able to do. And of course, leave to recover from childbirth or other related medical conditions. Again, also already covered by California law. Next slide, please. So when is an accommodation not required? I would say this is very, very, very limited. Again, overall, we want to lean towards accommodating a pregnant woman as much as possible. The law does provide some caveats. The undue hardship caveat, this is a common terminology and a defense that we can bring up wherever possible. And an employer does not have to provide a reasonable accommodation under the PWFA if it causes the employer an undue hardship. As defense counsel, particularly when it comes to larger organizations, it is a very difficult burden to meet, and it means a significant difficulty or expense. Again, case-by-case basis, it's always going to be a stretch, and so it's difficult to prove. Another caveat is the predictable assessments. So the regulations list certain accommodations that are almost always reasonable, called predictable assessments. For example, there are a limited number of simple modifications that will, in virtually all cases, be found to be reasonable accommodations that do not impose an undue hardship. So I think this is a good guidepost, but again, this is going to be a case-by-case basis generally when you're talking about undue hardship, which high bar. And so some of the predictable assessments that are always going to be reasonable accommodations that the employer should provide, carrying water and drink as needed during the workday, providing additional restroom breaks, sitting, standing, and providing breaks as needed to eat and drink. Those are also, I mean, a lot of this is fairly straightforward and common sense. But I think this is a good guidepost to pretty much always just grant those accommodations as requested.
Rachel, very briefly,
Yeah.
with accommodations, we foresee a lot of these issues, for instance, will be not just sitting, but what kind of special seating arrangement or what kind of special chair.
Right.
I mean, we've had cases where an employee has requested a massage chair. This is really prior to the enactment of the PWFA, excuse me. Who knows? I mean, theoretically, it's possible a massage chair could be a reasonable accommodation that an individual who has limitations due to pregnancy or childbirth may need that. And I say that in part in jest, but really what we're going to be litigating is how far is too far. And so with a number of these, there's possibility and potential for abuse. I'm sure that everyone in the audience has already had that thought, not once, not twice, but probably with almost every slide. And so lactation breaks are another one that I mentioned and referenced earlier. This has been a frequent issue because most employers, they know their obligations. They know that they're required to provide, that space that is not a restroom with a sink, all the things that the law already requires. But when we're looking under the PWFA, the tongue twister, of an act, we're thinking, is this now going to be breaks every hour, every 2 hours? How often a woman lactates really depends on her body and on her chemistry and biology and her personal decisions with respect to that particular process. So we predict there will be a lot of questions that push the bounds of reasonableness, and it will be really fascinating to see how that plays out, especially with these two specific areas.
Absolutely. So just summarily, let's talk about what the tongue twister, there you go, PWFA prohibits. It prohibits a failure to make a reasonable accommodation for the known limitations of an employer applicant unless the accommodation would cause an undue hardship, very familiar language. Requiring an employee to accept an accommodation other than a reasonable accommodation arrived at through the interactive process. Denying a job or job opportunity based on the need for reasonable accommodation. Again, obvious, familiar. Requiring an employee to take leave if another reasonable accommodation can be provided that would let the employee keep working. Because again, the ultimate goal is to allow the pregnant woman to keep working and stay and keep insurance. That is the ultimate goal. And also prohibits, punish, or retaliating against an employee or applicant for requesting or using a reasonable accommodation, reporting or opposing unlawful discrimination under the PWFA, or participating in a PWFA proceeding. Very similar to the FEHA retaliation statute here in California. And coercing individuals, I left out a word here, to stop exercising or helping others exercise their rights under the PWFA. So that is the PWFA in a nutshell. And now let's turn to what Alina referenced in the beginning, that there have been already some challenges. And although it's brand new, there are some cases that are pending that I think are worth mentioning. Next slide, please.
So probably without much surprise, and some of you may have read about this as well, there Tennessee and 16 other states challenged, and the fact that it's Tennessee, and I'll tell you which other states is important here too, challenged the aspect of the regulation dealing with elective abortions. When we first started our time together today, remember that we mentioned this protects limitations, really most limitations related to pregnancy, childbirth, and everything that happens post the birth of a child. Abortion, including those which are elective, is expressly protected by this act. An abortion prompted exclusively by the woman's choice, where there is no physical or mental condition that's related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions exists. But where getting the abortion creates some limitations on the employee's ability to do their job is really what's important. And the plaintiff states, or in the plaintiff states, excuse me, these elective abortion procedures are almost, and most abortions really are illegal. I know that's not a surprise to anyone, but we're talking about Kansas, Iowa, Missouri, Indiana, Alabama, Arkansas, Idaho, South Dakota, North Dakota, Florida, Georgia, Nebraska, West Virginia, Utah, Oklahoma, and South Carolina, which I almost left out. So these 17 states challenge that specific aspect because you cannot obtain an abortion in those states, period. So the regulation included those non-exhaustive list of examples which are covered by the Act. The states sought through a preliminary injunction or a stay under the Administrative Procedures Act to stop the entire regulation from taking effect. So the 17 states did not target just that specific portion or language. They really targeted the effect of the entire act. The states argued that applying the PWFA to elective abortions will cause sovereign and economic harms. The way they pled the sovereign harms is twofold. They argued that the rule will abridge their ability to regulate abortions and their interest in maintaining a pro-life message in dealing with state employees. Because again, the act is so broad and expansive that it applies to state employees. And then the economic harms are the rule-related compliance costs that the states say they will incur in response to the potential enforcement. And what they really mean by that on a basic level, even if an employee, so say the abortion is illegal, the elective abortion would be illegal in South Carolina or in Arkansas, and an employee is required to travel and take a week off from work, that is an actual economic harm, the states argue. These costs are unrecoverable because the commission, as an arm of the United States, enjoys sovereign immunity. So the states didn't actually claim any specific harm, but because they face imminent injury. So the court ultimately denied the state's motion for injunctive relief. The judge in Arkansas decided that they failed to show that the EEOC's rule was likely to cause the actual harms. The decision also really touched on the fact that a woman who has an abortion really cannot obtain it in that state, so there is no harm, but she is required to travel. She's required to travel elsewhere, and as a result, may need time off for that particular event or procedure. Now, also not surprising, this particular decision was appealed just recently, so we'll see exactly what the outcome is, but very interesting because in addition to that, next slide, please. In Louisiana, this very law was challenged again as well. There were two consolidated motions filed for preliminary injunctions. They were filed there by the states of Louisiana and Mississippi in the matter that you see. The interesting piece here is that we had 17 states challenge it, and then we had a separate lawsuit. There was a lot of amicus briefing here, of course. The ACLU joined. The plaintiffs asked the court to enjoin or to stop the defendants from enforcing an EEOC final rule that implemented and interpreted the PWA and also Title VII to the extent that it requires employers to accommodate the purely elective abortions of employees. So very, very similar in nature. The plaintiffs also asked the court to postpone pending judicial review of the effective date of the portion of the final rule mandating that covered employers provided workplace accommodations for purely elective abortions. So slightly different casting, slightly different procedural posture and the way it was challenged. Only two states, of course, here, but a very, very similar intention is the challenge is at the end of the day, in very basic terms, to purely elective abortions. And here, the main difference is the argument was that, again, employers who are covered by the act should not have to provide workplace accommodations in these states for purely elective abortions. The court found that the EEOC actually exceeded its statutory authority to implement the PWFA, and in doing so, both unlawfully and inappropriately expropriated the authority of Congress, so encroached on the sovereignty of state plaintiffs, again, because it would require specific accommodations, which cost money. The court granted in part the motion for preliminary injunction, postponing the effective date of the final rule's requirement that, and here's the key, covered entities to provide accommodations for the elective abortions of employees that are not necessary to treat a medical condition related to pregnancy. So it is a narrower ask, and the court was receptive to it. We'll see how this also ultimately plays out as well. Next slide, please. Now, as the PWFA really takes effect, and we see exactly how employers implement it and what types of accommodations employees really request beyond what we traditionally have seen, don't forget also about the interplay with other acts. The ADA, of course, which we touched on, provides other protections because the PWFA is really focused on just accommodations. So it really isn't focused on specifically on termination or other matters like retaliation, for instance. So keep the ADA in mind as well. That may be applicable if we're not talking about just the limitation. The FMLA, of course, is a separate protection. Title VII, the Pump Act, which was enacted really pretty recently and provides specific protections for individuals who need to express breast milk in the workplace and need breaks related to that. And then state laws, which provide additional benefits above and beyond, like California, for instance. And California, again, is alone or among very few in that bucket, but keep in mind that states may offer additional protections and that an individual who is covered by the PWFA is still entitled to additional protections as well. So being mindful and cognizant of the interplay of these laws is really important as well. So not to complicate things, but I think that EEOC has done that for us here. And happy to take questions. I think we'll turn it over to Faith and Ashley then.
Thank you. Great job. Very interesting. Okay, Autumn, if you want to go to the next couple of slides, please. Okay, next one. There we go. So this update on guidelines on workplace harassment just came out in April of this year, but the last time anything was updated was 1999. So it had been a bit. And next slide, Autumn.
So if anybody feels overwhelmed yet, you should, because EEOC has been very busy. And really what Faith and I are going to present on today is reaffirming some of the things the EEOC has done in the past, things that we all know, protected categories, those types of things. But I would really encourage everyone to go to the really dense enforcement guidance that the EEOC has on their website. So they give examples under really every single characteristic and have come up with examples of what they consider to be discriminatory conduct. And I felt that those examples were really helpful, especially in some of these new areas where they've expanded some of the definitions or the characteristics are a lot broader now. So I would encourage everyone to do that. So what are we looking at? So one of the things that we know with this new guidance is for harassment to violate the law, it has to be based on a legally protected characteristic. So what does that mean? So for example, if you're rude or teasing or mistreating someone because of a personality conflict or some kind of thing like that, maybe a bullying type of thing, and it's not connected to a protected category, then that does not violate the law. Now, most of us would already know that. It clarifies that. I know a lot of policies that you will have probably still would encompass protection against those types of things. But for the EEOC's purpose, what we're looking at, it has to be based on a legally protected characteristic. The other piece that they've clarified, it has to also involve a change to the victim's employment or create a hostile work environment. So the or is a very strong piece of this. And so what are we looking at that? It has to have harassment is so severe. And what the EEOC guidance now says is frequent, which we use the word pervasive, right? Because that's what we're used to. But it's the same thing under the guidance. So it has to be severe or pervasive / frequent that a reasonable person in an employee's position would find the situation to be abusive. The objective and the subjective piece of that is still included, but this is one of the things that we're looking at. The other thing from the victim's employment standpoint, involving a change to the victim's employment, what are we looking at? I would consider this to be like kind of an adverse employment action. So we're looking at whether they were terminated demoted, denied a promotion, reassigned, receives reduced hours, those types of things. So that's what we're looking at for harassment to violate the law. Next one. So as you all know, what are we looking at? What does the EEOC regulate, and what are we thinking about? So the new guidance basically just sets up as what we're used to. Race, color, religion, sex. Sex is definitely broader. It's going to encompass some of the Supreme Court decisions that have come out in the last few years with sexual orientation and gender identity, national origin, disability, age, and genetic information. So we're all pretty comfortable with these characteristics. But like I said, the one thing, if you take away anything from this webinar today, is all of these are slightly broader than they were before. Things that we may have argued wouldn't fall in those categories. Now, I would say that the rule of thumb should be that they do. So we'll go through some of those examples as we go through the PowerPoint. Next slide. So let's talk about race-based harassment. As we all know, again, this is basically any traits or characteristics linked to a person's race, such as their name, their dress, their accent, their speech pattern. Now they've clarified that this protection also is physical characteristics, including hair texture, hairstyle, appearance standard. The other thing that the guidance explains is that it's also color-based harassment. So for example, if a supervisor harasses an African-American employee with a darker complexion, but does not harass the African-American employee with a lighter complexion or skin tone, that would be considered to be race-based harassment. The other thing that we're looking at is any kind of displaying of offensive materials, nooses, swastikas. We would all assume that would be race-based harassment, or saying or writing any kind of ethnic, racial, or sex-based slurs. So again, slightly expanded in what we're looking at to qualify for race-based harassment. But that theme is going to continue on into national origin-based harassment. So as you guys know, the national origin-based harassment is discrimination due to the complainant's ancestors, place of origin, those types of things. Some of the clarification in the guidance is mocking a person's accent, talking about whether or not they can speak English well. Do they understand English well? Do they have a problem with that? Those are the types of things that the EEOC is going to potentially consider to be national origin-based harassment. And I think that this is one of those characteristics that is going to see some of the greater expansion under the guidance. And as everybody knows, the guidance is guidance, right? So the EEOC is going to obviously control various things that it controls and providing guidance to Title VII. We're also going to have to deal with our state laws, but the EEOC is coming first on a lot of this stuff. So we expect that once we see kind of the litigation with the EEOC unfolding, as we see position statements and how we're getting through those, we're really going to get a handle on how broad this is. But I do think that we'll all be surprised at how far the EEOC is going to go and basically enforcing what they consider to be this, new and exciting guidance. Next slide. So as we know, religious-based harassment is also covered. So this is religious stereotypes, requests for religious accommodations. The guidance also clarifies that even an atheist who doesn't have a religious belief, if they are threatened or intimidated in the workplace because of their lack of religious beliefs, that this would be covered as well. So this is, again, a broadening of what we would consider to be religious-based harassment.
Not true.
Yes. Did I hear my name?
I think if everyone could mute, that would be super, super helpful. I think maybe there's some that are still not muted, Ashley.
Okay, no big deal.
Yeah.
And sex-based harassment is something that Faith is going to go into a little bit because it really, and Faith, see if you agree with me on this, but I think it actually has the largest expansion under the guidance.
Yes, absolutely. So the interesting thing about sexual harassment is, we think of the quintessential quid pro quo, I think, a lot of times, where it's, if you go on a date with me, then I'll give you this promotion. Or if you don't go on this date with me, then you're going to be demoted. But obviously that it's more than that with the hostile work environment. In addition, it can be just sex-based harassment. So really this guideline, Ashley's right. I mean, it talks a lot about just how expansive the protected categories can be. So of course, with sex-based harassment, you think of, again, the sexualized nature of some sort of content, like showing pornography or sexually demeaning objects, to, the quid pro quo. It also extends beyond just sex gender roles, but into pregnancy, childbirth, related medical conditions, lactation, birth control, or the non-use of contraception. It all expands under the umbrella of sex discrimination and sex-based harassment. Next slide, please. The guidelines also updated following the Bostock decision to include gender identity and sexual orientation as part of sex discrimination and can be sex harassment. So they include examples on what would be considered, prohibited is asking intrusive questions about a person's sexual orientation or the transition, talking about intimate body parts. Another thing that the EEOC talks about is dead naming. So using a name used by the person prior to a transition and denying a person access to restrooms. Next slide.
And just to follow up on Faith's point, one of the other things that the guidance talks a lot about in the sex-based discrimination is essentially that it doesn't always have to be sexual in nature. So, you could have man-on-man harassment that doesn't have anything to do with any kind of gender orientation whatsoever, but that would still qualify potentially as sex-based harassment or female-on-female, whatever it may be. But the definition is really expanded. And they talk a lot about, we've in the past kind of focused on this sexual part. It has to be very sexual in nature. And I would stop thinking about it like that. I would think about it as a very, sex-based discrimination rather than that. Just as a little point to add. As we know, again, we're kind of ticking through our normal characteristics and protected categories that we're used to. Age-based discrimination is obviously one that we all have to worry about. And some of the clarification on this one is negative perceptions about older workers or stereotypes. And some of the stereotypes that the guidance talks about are like, are they as, an older person may not be as technology focused. What if they can't do the computer programs? Asking someone when they're going to retire, giving nicknames, the older person, the old guy, pops, whatever it might be. They're really looking at the stereotypes of older workers. Of course, I think we would all agree that 40 doesn't seem very old, but anybody, of course, over 40 that have these stereotypes of they're not able to keep up with technology. That's the type of thing that's going to be an age-based discrimination now, and jokes about those types of things and participating in jokes about those types of things are what the EEOC is going to be looking at in age-based discrimination. Next slide. Rounding out the end of this, of course, we have disability-based discrimination, and we all know that has to do with anybody's physical or mental disabilities. The same types of things are always going to apply. So, of course, if you have a disability, if you're regarded as having a disability, those are all still in place. But the other things that the guidance is really focusing on is the individual's request or receipt of the accommodation. So if somebody feels like they're getting more time to do something, and employees are teasing them about getting a break or teasing them about having an easier way about it. Those are the types of things the EEOC is going to look at for disability-based discrimination. They're going to also look, which I thought was really interesting, at a person's association with a disabled person. So if you're giving your employee a hard time or teasing them about their association with a disabled person, and the guidance talks about someone's spouse having COVID, long COVID, and that being a disability, and teasing the employee about having to take them to the doctor or teasing them about their spouse who has a disability, that is now included in what would be considered to be disability-based discrimination. So very much broader, and looking at the stereotypes about how people walk, how they speak, how they move, teasing them maybe about having a stutter. Those are all the things that are now going to be really encompassed in this disability-based discrimination that we're going to have to make sure that we're prohibiting in our workplace.
Well, and Ashley, Oh, so I was going to say, we always, I know we advise our clients and we hear all the time where to, not diagnose, like you're not a healthcare provider, but we hear often, complaints, well, that person's just crazy or that person's just losing their mind. I mean, so those kinds of comments that might just be sort of offhanded comments can become harassment in this context. So just something to be aware of when you hear maybe some of the management making kind of comments like that about employees, it could be a big problem.
And as we all know, under the amendments to the ADA, obviously the definition of impairments had expanded. And so now kind of the piece of the harassment is expanding based on those impairments. So this really is a wide ranging issue now that's going to affect every workplace. Last but not least, although I've never had one of these cases, I've never had a genetic based discrimination case, but it's in there.
I've had one.
So any kind of harassment based on individuals, family members, genetic testing. So this would be, for example, a gene, if someone had a gene related to linked to cancer, maybe, and some of the guidance talks about the breast cancer gene, those types of things, discriminating based on that. So again, I've never had one of these cases. I'm interested to hear people who have had them, but this is always kind of rounding out the protected characteristics. Okay.
Yes. All right. So this is to us at least, a pretty big add-on or a focus that the EEOC provides in the guidelines, where they really talk about causation. And so causation is established if the evidence shows that the complainant was subjected to the harassment because of the complainant's characteristics or the protected characteristics. And they look at a totality of circumstances and a number of different types of principles. Again, not all, they don't have to all tick through. I mean, it's not an exhaustive list, but these are the things they're going to look at. Next slide, please. So some of the factors to establish causation, your typical, what you would imagine, facially discriminatory conduct. So direct, insults or threats to a protected category. It doesn't matter, and they emphasize this in the guidelines a couple of different times, whether it's positive, negative, neutral, or any intention. So even if the person said, I was intending it for a joke, that doesn't matter. As long as it was said, that's going to be considered one of the factors for causation. Stereotypes, again, they don't need to be motivated by some kind of animus. The EEOC gives the example of suggesting to an older employee that they should retire to enjoy their golden years. That was an example they gave that could be age-based harassment because of the stereotype that old people need to stop working, basically. Another one was a female worker with children should go part-time so she can spend more time with her children. So those types of stereotypes we're going to look at. Context, which is always really important when you're looking at these types of claims anyway. I mean, I always give the example in training, me saying, hi, how are you? Just on his face is not, I don't think, objectively or subjectively harassing. However, if I'm getting really close to somebody and I say it in a really suggestive way and sort of in a creepy way, that changes everything. So it's all about context. But it's really interesting. The EEOC adds that it's the context, inflection, tone of voice, and historical usage of a term. The example they give, which I think is helpful, it says Ron is a black truck driver, finds banana peels in his truck on multiple occasions. After 3 times seeing these peels, he sees 2 of his white coworkers watching his reaction. There's no evidence that the peels were on anybody else's truck, and there's no other trash found in Ron's truck. So the EEOC says, based on these facts, the appearance of the banana peels on Ron's truck is likely not coincidental. And further, because the peels are used to invoke monkey imagery, it would be reasonable to conclude, given the history of racial stereotypes against Black individuals, the peels were intended as a racial insult. Therefore, those circumstances can be harassment based on race. So context is going to be really important when we're looking at causation. Next slide. A link between the conduct that's not exactly explicitly connected to the protected category. The example the EEOC gives is somebody who's religious in nature and everybody knows about it. Then the coworkers swear in front of this person, which is against her religion. So it's sort of an indirect way of harassing her based on her religion, because the coworkers know that that would be against her beliefs. Timing. So if any harassment starts or worsens after finding out about a protected category, that's something the EEOC is going to look at in the totality of the circumstances. And then comparative evidence. The example that the EEOC gives in the guidelines is Tyler is a manager at an educational services firm who manages 2 women and 2 men. Tyler regularly hovers over the women so they don't mess up and yells and shakes his fists at them when he's angry. He engages in friendly banter with the men and even allows them to relax in his office sometimes. Tyler's treatment of the men is different than the women who are similarly situated to the men, and therefore it's based on sex. So we're really kind of talking more about, in a way, sex discrimination and what we would typically look at on a McDonnell-Douglas standard. But here the EEOC is adding it into the causation. Next slide. Again, these are not exclusive, but these are examples of ways in which harassment can be based on sex. So again, we talked about the quid pro quo, so proposals of sexual activity, hostility toward a member of an individual sex, and then comparative evidence. Next slide.
So the other thing that this guidance does, it clarifies some things that we already knew, probably have been advising on for years and have been watching, but really solidifies what we're thinking about. So what are we looking at here? Conduct outside of work. So obviously harassing conduct that's occurring outside of the regular place of work can still obviously violate the law, violate the EEOC's guidelines. But we're looking at employer-sponsored hosted events, off-site behavior. This is all kind of, as we expected, coming from a lot of work at home type of things. Also, posting on social media accounts. Can that create a hostile work environment? Absolutely. If it impacts the workplace. Comments made during video meetings, typed in a group chat, those types of things. Again, I've always, counseled different employers that our outside work conduct is definitely relevant and have gotten pushback from some folks on that occasionally. But this just really crystallizes that the EEOC is going to look at these issues. Next slide. The other thing that we're looking at is through this guidance, and again, just clarification of this, but even if the complainant is continuing to perform well, it can still be an objectively hostile work environment. So even though the work performance is staying the same, there doesn't have to be any psychological injury to that. It still can be sufficient to create a hostile work environment if the harassing conduct made it more difficult, it's not a very stringent standard for a reasonable person in the position to do their job. So again, this is just something to highlight for you, that even though the person seemingly is still doing all the things they did before, as long as a reasonable person, it would be more difficult for them to have done their job. This is going to potentially qualify as something that we need to watch. Next slide. The other thing that we want to make sure that everybody takes away from this is this joint employer liability. As we all know, joint employer liability is a little bit of a moving target on a regular basis. But one of the things the EEOC is going to tell us is, of course, both, if you have an independent contractor, if you have a temporary agency, any type of things like that, both individuals or both companies are going to have responsibility to investigate and prevent harassment. So both the agency and the client have the responsibility to take the corrective action. Both have to have the, go through the process and do the investigation, and both have to correct the harassment for both permanent and non-direct hire employees. So again, I would assume that would already be the case. This is just enforcing and clarifying that that's out there and that we need to make sure that everyone's aware of that. Next slide. So this is interesting. What are the other covered bases and what we've talked about before? And so there's two kind of what I would call newer developments. So we have to look at perceived protected characteristics. Even if the perception is incorrect, the related conduct still constitutes unlawful harassment under federal anti-discrimination law. So even if you're not right about it, then it still can be harassment. And harassment based on association. So harassment based on the person's association with someone who doesn't share the same protected characteristic as the victim may also violate the law. One of the examples they give, harassment of a white employee because his spouse is African American, or harassment of a Black employee because she has a biracial child. So those are the two things that they are looking at. So someone who has an association with someone who has a protected characteristic, then that is now by the EEOC's guidance covered and something that is prohibited. Next slide.
So expanding again areas and making it pretty clear what will be considered harassment. So intra-class harassment, the example they give is male employees harassing a male coworker. Because a lot of times we'll hear pushback, well, it's that their manager's a woman. She's not harassing another woman. It's like that it could still be intra-class harassment. Intersectional harassment, the example they use is discrimination against Black women, even in the absence of discrimination against Black men or white women. Next slide. Always remember that retaliation is something to be careful about and ensure that employees are able to voice complaints and participate in any investigations without any kind of unlawful retaliation. So really just trying to reiterate that there could be retaliatory harassment as well. So we gotta be careful on that. Next slide. Just like the earlier presentation, there's been a challenge already in May. 18 Republican states filed a lawsuit trying to block enforcement of this guidance as it relates to the transgender employees. So the states include Tennessee, Alabama, Alaska, Arkansas, Georgia, Indiana, Iowa, Kansas, Kentucky, Mississippi, Missouri, Nebraska, Ohio, South Carolina, South Dakota, Utah, Virginia, and West Virginia. To be determined, right? Just want you to be aware that's out there. Not really a big surprise, but that's the only thing we've seen at least so far on it. Next slide. So practical takeaways, and Ashley and I used to talk about when the hashtag Me Too was prevalent prior to COVID, and it still is, we would say hashtag not here. So this is where your hashtag not here at your companies comes into play. So we got to make sure we're updating our policies, particularly with the expansive protected categories from Bostock and some of the other ones. We got to make sure that those are covered. And then training. I mean, that's your managers need to know to report this and make sure it's investigated and taken care of. Your managers need to know what's going on. And then, of course, employees need to have a place to complain. A lot of our clients are doing anonymous call-ins or anonymous emails and having various places in which employees can voice concerns so they don't feel like they'll be retaliated against. And particularly if the harasser is someone in HR, for example, we might need to make sure they have another avenue to report. Next slide, please. The EEOC talks about making sure that the employees are able to understand the policies and any training. So is there any kind of language barrier or other barriers to understanding? So to make sure that we're covering that, not just throwing, a paper at them when they start and having them initial, but to make sure we sit and actually do some training and talking about these policies with the employees if we can, which I know is even harder now because everyone's remote and everything's electronic. But that's something the EEOC talks about. It's really important. And we always talk about leaders should lead by examples. Your high leaders up in your company should know about what's going on and trying to prevent disrespectful behavior. I mean, a lot of times these cases, and Ashley, I'm sure you would agree, it starts with maybe just a miscommunication or a personality conflict, and then it escalates. And so, we want to make sure that all of our managers and leaders are treating people with respect and having an open communication. And that goes a really long way. Next slide, please. Okay, any questions? We ended a little early as I'm sure you all want to hear more about this, but now you can get back to your day unless we want to chat about anything.
Yeah, the one thing I would say just at the very end is that, 25 years, as Faith said at the very beginning, that the EEOC hasn't issued an updated guidance. So this is going to be kind of what we're going to be looking at, our manual for a while. So these are pretty significant changes. And we're going to have to see for case law and everybody, fighting about what some of these words mean and what are the expansive protections to see what in 5 years we'll look back and say, okay, now that this means that, right? And we don't know that right now. What we do know, though, is for the first time in 25 years, we have a new manual. And so one of the things I think it would be very helpful, and we mentioned this in kind of your practical takeaways, but look back at your employee handbook. Make sure that your characteristics are covered, that these expansions are incorporated in your handbook. And then, of course, as we always say, you can't help but do training on this stuff. That's the most critical piece of both what Faith was talking about, Alina and Rachel. These are things that we're going to be now dealing with for the next 5 to 10 years. And so we just wanted to make sure everybody felt comfortable, at least to issue spot these things. And then we can develop them as, and obviously talk about them more as the case law develops.
Does anybody have any questions? I didn't see anything specific in the chat. Of course, you can always email us. We're here ready to help. Okay, without any questions, thank you so much for everybody for joining, and we really appreciate you and hope to see everybody soon.